In the matter of the State of South Carolina against Richard Alexander Murdaugh, 2022 GS 15-00592, 593, 594, and 595. The following constitutes my ruling on this matter from the bench. This order will be supplemented, as I will explain, after proposed formal orders are received from each side in this matter. This case is unique in my 20 years of experience as a lawyer and my 35 years of experience as an active justice of the Supreme Court and a senior active trial and appellate judge. Usually matters involving possible improper contact with or conduct of a juror arise during or shortly after the trial. The judge then puts the affected juror or jurors under oath, conducts an examination, and rules on the request for a new trial or a mistrial. In this case, I was appointed almost 9 months after the trial to replace the trial judge who was recused. It is now almost 10 months after the verdict was rendered and sentence imposed in this matter. It is now on appeal to the Court of Appeals. Several months after the appeal was filed, the defendant moved that his appeal be suspended and this matter be remanded to the trial court to consider his motion for a new trial on a charge that the clerk of court for Colleton County tampered with the jury by expressing her opinion to the jurors about what their verdict should be and about the credibility of the defendant who had elected to take the stand and testify on his own behalf. Since this matter has been remanded to me, I have set the matter for a pretrial and a final hearing, conducted a telephonic status conference with the attorneys for the parties on December the 21st, 2023. I have received briefs from the parties. I conducted a pretrial proceeding on January the 16th, 2024, in which I invited briefs and arguments by the parties and by the attorneys for certain of the jurors and for the clerk of court, Rebecca Hill. On Friday, January the 26th, 2024, I conducted a hearing on this matter in which I took testimony from one of the jurors. The conduct of the examination conducted solely by me. I received further argument from the attorneys for the state and for the defendant. Today, January the 29th, 2024, I have taken sworn testimony from the remaining 11 jurors who rendered a verdict in this case. This examination was conducted solely by me. I have found no case that provides otherwise in the many cases I have read on the subject of a motion for a new trial on the basis of after discovered evidence of jury tampering or misconduct. I have also received sworn testimony from the clerk of court, Rebecca Hill. Direct examination was conducted by Deputy Attorney General Creighton Waters. Cross-examination was conducted by Defendant Attorney Richard Harpootlian. I have also propounded questions myself to the clerk of court. I also received testimony from the clerk of court for Barnwell County, Rhonda McElveen, who attended most of the trial and assisted the clerk of court for Colleton County. I've also received testimony from the remaining alternate juror who was, when the matter was deliberated, dismissed from further service. The following is my ruling on the defendant's motion. The standard of proof. The state contends that in order to prevail, the defendant must show, 1, that the clerk of court made an improper comment or propounded an improper question to the member of the jury, to a member of the jury who rendered the verdict. 2, defendant must further show that Ms. Hill's improper comment or question actually influenced the jurors' verdict, citing State v. Green, State v. Aldrett, and other opinions of our Supreme Court and other authorities. Defendant contends that he must show only that an improper question or comment was propounded to any juror by a clerk of court Hill. If so proved, the defendant contends that the motion for the new trial must be granted. Defendant relies on United States v. Rimmer and many other cases. My ruling is this. On the law, the defendant has the burden of proving both the fact of the improper comment or question by the clerk of court, Rebecca Hill, to a juror or jurors, and two, prejudice suffered by the defendant, specifically that the Hill improper comments to the juror or jurors influenced the juror to vote to convict defendant Murdaugh. The facts. Did clerk of court Hill make comments to any juror which expressed her opinion of what the verdict would be? Ms. Hill denies A, and so the question becomes, was her denial credible? I find that the clerk of court is not completely credible as a witness. Ms. Hill was attracted by the siren call of celebrity. She wanted to write a book about the trial and expressed that as early as November 2022, long before the trial began. She denies that this is so, but I find that she stated to the clerk of court, Rhonda McElveen, and others, her desire for a guilty verdict because it would sell books. She made comments about Murdaugh's demeanor as he testified, and she made some of those comments before he testified to at least one and maybe more jurors. Did clerk of court Hill's comments have any impact on the verdict of the jury? I find that the answer to this question is no. Each member of this jury took their involuntary assignment very seriously. They obeyed the instructions of the court. They obeyed their oath. These good and decent citizens of Colleton County stood to their duty and rendered their verdict without fear or favor. It was a difficult task. 11 of the jurors very unconditionally said they either heard no comment, or if they heard a comment, it had no effect. One juror was ambivalent in her testimony. She was then examined on her previous affidavit, in which she said the effect, if any, that she had was pressure she felt from other jurors. The cases are myriad that pressure from fellow jurors is a part of the normal give and take of jury deliberations. The court is not to inquire in any way about what is said in those deliberations. But the juror was somewhat ambivalent, said on her oath at the time of trial twice, and said on her oath before me in these proceedings that she stood to her oath. The clerk of court allowed public attention of the moment to overcome her duty. I have read the entire transcript of this lengthy trial, not an easy task. I have studied in detail all of the authorities cited. I have independently researched the case law, learned treatises, and scholarly articles on the subject. Although there is certainly a split in the federal circuits and in the states on the standard of review, I simply do not believe that the authority of our South Carolina Supreme Court requires a new trial in a very lengthy trial such as this on the strength of some fleeting and foolish comments by a publicity-influenced clerk of court. This is a matter within the discretion of the trial judge, and I am the trial judge at this moment. I do not feel that I abuse my discretion when I find the defendant's motion for a new trial on the factual record before me must be denied, and it is so ordered. I will file a fuller order which denies this motion on the grounds I have recited on the record before me as a trial judge and the authorities that have been cited by all parties in this matter. To that end, I will hold the record open. I direct that within 4 business days of receipt by the attorneys in this matter of a transcript of these proceedings, a proposed order by the state denying the defendant's motion for a new trial with citations be sent to me and to opposing counsel. I will allow the defendant 4 business days from receipt of the state's proposed order to lodge objections and or submit an alternative proposed order. Upon receipt by the court of all proposed orders, I will finalize this record, submit a written order, and I will at that time transmit the written order to the Court of Appeals, the court which has remanded this matter to me. This hearing is adjourned.